So we want all of you to make use of it. So that is also the intention why I am here, because I believe all of you are in which year? Are you final years or fourth years, third years, or
Third year.
third year students? So I think it's the right time wherein we can talk about intellectual property, innovation, and all, because I think next year you're supposed to do your projects, right? And considering you might be seeing in newspapers, central government is coming up with a lot of schemes on innovation, and then schemes specifically for student innovators, startups, and all that. There is a lot of schemes. Even in fact, our college also has certain new entities that have come up, wherein it can provide you all kinds of mentorship in terms of maybe financial mentorship, maybe in terms of IP filing aspects, which we deal with. So we have certain facilities, because rather than you all joining an employer and working with them, now the whole country is looking at all of you as innovators, wherein you can commercialize them and you can make your own profit, and in that way even economic development happens. That's what is expected from all of you as future engineers, unlike 10 years back or 15 years back, wherein everyone was expected to finish their course, go join a multinational company and work with them. So you are expected to be a part of a different ecosystem, right? So I hope at least few of you come forward and maybe start your own startups and other ventures which will help the country in turn. So towards that, so keeping that in mind is what I'm going to focus the discussion today, wherein we are going to discuss a little bit about specifically about medical innovations, what is exactly the situation in India. And maybe if you are interested, we can even venture into other jurisdictions. And mainly when you deal with medical devices, or when you are into research or any kind of innovation related aspect related to medical devices, what are exactly the factors which are related to ethics, which are related to morality and law, which you are supposed to keep in mind. So I have structured the lecture keeping in mind that you are already introduced to ethics and the procedure related to patenting, or maybe drafting of claims and other aspects. So, do you expect me to give a small overview and then start, or can we just start right away?
It's good to have an overview, ma'am. They've not gone
Okay.
in there.
Okay, no problem. So we'll just look into quickly what exactly is the patent landscape in India, and then I'll also focus on because there is a lot of common factors international level as well. But to start with, you might have heard about, when I talk about intellectual property, we are talking about several kinds of IP, or basically intellectual endeavors, wherein it can generate some kind of income for the inventor. At the same time, the public can use it. So mostly what happens when I talk about intellectual property, or you might have heard, there are trademarks, there are copyrights, and then there are of course patents, etc., etc. So when you start thinking about these different forms of intellectual property, there might be other forms of intellectual property which you might not have heard so much, or like semiconductors and integrated circuits. You come up with a new circuit system, you can actually register it as an IP. Then designs you might be introduced to already. Then we have geographical indications. Then we have plant variety protection. When you come with a new hybrid variety or a new variety, then you can claim it as your own GI, produce the seeds in bulk, sell it to the farmers, and get profit out of it. So there are many new forms of IP as well coming. And then the most obvious one, that is trade secret. Because majorly why I am focusing on trade secret initially itself, when you start your research, mostly researchers have a tendency wherein they feel that, okay, I should somehow get a patent for my innovation. Not Do not think like that. It's not always necessary. Even or you are planning to start an enterprise, and for that you have something very innovative. And don't always be adamant that you need to get a patent, then only you will go forward. It's not necessary, because patent, there are specific intentions behind giving patent law, both to the government as well as from the public. And it's not necessary that something that you have come up with need to come under the purview of patent protection, wherein then only you will generate profit. There's nothing like that. Sometimes they can see, look at patent protection. The problem is, you might already be knowing, you can have rights over it only for a term of 20 years. What happens after 20 years? Nobody need to bother about you. Anybody can take up your invention and do anything about it. But have you seen what Coca-Cola is doing? They are generating profit out of their trade secret for such a long period of time. It's more than almost a century. So there lies the decision making power of an entity or an entrepreneur, whether to, if there is possibility wherein the technology you have come up with, it can be maintained as a trade secret, never ever think about getting a patent, because government gives you patent on the condition that first you have to disclose all the information about your invention to the government. Simply they'll not give you patent. This is the whole ideology. So now that is why, always don't start your research with the intention that my intention is to get a patent so that I can earn money. It's not necessary that in spite of getting a patent, you might still not be able to earn money. So what is the ultimate intention is, make sure whatever research you're doing, whatever innovation you're trying to come up in the existing state of the art, that is going to be useful to the public or the area you're focusing on, or the stakeholders in the area. That is what is going to generate information. I know I'm like contradicting my area of study, wherein I am trying to tell you don't give too much attention to intellectual property, but I am talking from the reality perspective. Don't think that patent is everything and patent is what decides your future, because many of the technology that comes in the market sometimes are not patented. So that is why, never keep an intention in your mind that getting a patent is my objective. No, that is not. Generation of commercial value, coming up commercial value means the moment consumers are interested in your product, or patients or hospitals are interested in your product, you will definitely generate revenue. So patent is not the condition precedent, right? Don't always have that mindset first of all. Now so we will start with, what I'm going to do is, I'll just, for 15-20 minutes, I'll give you an overview of patent law, and then we'll talk about specific different kind of medical inventions. And then we'll also, if time permits, I'll also show you few claims, wherein what you have to keep in mind while framing these claims and other parts of your patent application while applying for the same. Can you see the screen I have shared?
No, ma'am.
All right. Is it visible now?
Yes, ma'am.
All right. Okay. Yes. So now, to start with patents, I'll ask you a question. To understand this concept of patent, I expect an interactive session. So I expect all of you to talk. Uh, See, who do you think? When we talk about grant of a patent, or when you all of you might be knowing that patent is when there is an innovation, and the government is trying to give you the status of a patent holder, and they are giving you certain incentives because you have invented something, right? That means you have done an innovation. Now, who do you think benefit from a patent?
The creators,
The creator. How do you think the creator benefits from the patent? What is the benefit of the creator when we are talking about a patent? What is that? You said that the creator is the one who benefits out of the patent, right? What do you think? How does the creator get any benefit? Is it monetary benefit, or is it something in kind, or how exactly does it happen?
they get protection from the government for what they've done.
They get protection from the government for what they have done. So anybody having any other perspective with regard to patent, other than the inventor? Is there anybody who gets benefited?
I'm both government and inventor.
Good, good. Okay. So how does the government gets benefited?
Like if the product or anything is sold, the
Mhm.
government will also have some part of the share.
You mean to say tax? Tax
Yeah,
is
yeah,
a form of
yeah. Yes,
taxation.
ma'am.
Okay. Yes. So now I'm going to tell you what is exactly the rationale, or why we have this patent system or patent protection in all the countries. First of all, first thing you need to understand is there is no concept of international patents. There are certain systems wherein internationally at the same time 10 or 20 countries you can apply for patent protection, but there is no concept known as international patent wherein you file it with World Intellectual Property Organization and you will get patent protection in 5 or 6 or all the countries simultaneously. There is nothing like that. Always patents has to be granted by that respective country. So if you have an invention and you are planning to commercialize in US and India at the same time, you have to file separate patent applications both in India as well as in US. So there's no concept of international patent. So during the course of our discussion, I'll justify why there can't be a international patent, and it is more or less related to your area of research, that is medical innovations. So now, talking about this, who benefits out of a patent? There are three sets of people who usually benefit out of patent, and two you have got it right. That is, one is government, then second one is you, the innovators or the creator, and there is a third set of people. Do you know who is that? That is none other than people like me. That means the normal consumers or the public. Now I am going to justify from this patent protection from the perspective of all these three people. That is this government, then you have common man, and then you have your scientists or inventors or creators, whatever you call them, right? So what happens, the whole system works like a, we can government and the creator, their relationship can be taken something like your teacher and the classroom. Like for example, here there are around 30 of you, right? So now your ma'am is doing a test, so ma'am is like the government here and you are all innovators or creators. So usually what she does is, somebody who comes or scores highest mark in a test, what would she do? She might, the teacher might sometimes give some gift. So there is two intention behind this. One is she wants to encourage the person who has done well in the test. Second one is that particular act of giving the prize to the student who scored highest. She is trying to create a kind of seal among the other students so that for the next test they'll all work hard and study better, right? So this is exactly the strategy between the government and whom? Government and the creator. The government wants innovations to happen in the country. Why government wants innovation, we'll talk about it. So in order to increase the number of innovations, what government is doing, when somebody comes up with an invention which fulfills, there are certain criteria, they will not simply grant patent status to each and every innovation, but once there is an innovation which fulfills the criteria, then what the government will do, they'll say yes, good job. How are they saying good job to the creator? They're saying, okay, you give us all the information, then they will check, go through the information. There is a specific process for that, we will discuss about it. And if the government is convinced with related to the amount of disclosure you have made and other criteria under the patent act, then they will grant you the status of a patentee. Till then you were just an inventor. That means you just have the invention, and by chance somebody else gets access to your information, that's it. They can do whatever they want with your innovation. They can publish it, they can commercialize it, they don't have to take your permission. Now what happens when the government steps in and government takes the information and he is giving you the status of a patentee? That means from innovator you are now getting promoted to whom? Promoted to patentee. Here the advantage is that intellectual endeavor, the invention you have done, it is getting recognized as a movable property which you own. And when you, so that means it comes with a bundle. This bundle gives you certain rights. That means you can sell that particular invention to whoever you want. Suppose you don't have money to market, what's the point of keeping it, right? So you can sell it to a company, and money you can decide, negotiate with the company, nobody is going to come and interfere. You can decide. If it's a product patent, then the product has to go into the market, somebody has to fix the price, government is not going to interfere. Government will say you can put whatever price you want, and there is no, you can create a monopoly in the market. Because usually the usual practice in India is, if you try creating a monopoly, government will come and catch you through certain laws. That will not happen. You can create a monopoly, you can be the sole person who produces and distributes that process in that particular product in the market, or you can license it to certain other companies and get profit out of it. So for a span of 20 years, government is never going to intervene. You can do whatever you want with the innovation. So, and at the same time, if somebody is trying to steal your innovation, then they can also be punished under the patent laws. So this only happens if you travel from the status of inventor to the patentee. So that is exactly how government is saying, see, you did a nice job by coming up with a new invention. So this actually, why they are doing it is from the creator's perspective or the researcher's perspective. One is you are getting benefits out of it for a span of 20 years. After 20 years, definitely it falls in the public domain. Now, how it will benefit the other researchers is, see, if you notice how I started the sentence, I said government will give you patent provided you disclose all the information about your invention, right? So that is what you do during patent filing. You might have studied, right? There is something known as specifications, complete specification and provisional specification. So these, through these provisional specification, you are actually giving all the details about your innovation. Now, from the date of application, and after that, about 12 to 18 months within that, you can also go for a speedy publication also. The government will put all the information related to your information in innovation in the public domain. So this information will be available for this 20 years. The advantage here is it will avoid duplication of research work. Otherwise, what will happen? I am an inventor, I have invented something. Now I am scared to disclose it to my friend, because I am scared that he might take it, he might start, he has the money, he might start a company, he will commercialize it. So I'll just keep quiet. At the end, nobody would know I'm doing research. I have already found something so important. Some other entity might invest money and do research on the same thing. It's waste of efforts of the country, waste of efforts of the entity individual, right? So if information about your invention is available online, such duplication in terms of research, may it be research done by students, may it be research done by any other multinational corporations, government entities, it can be avoided. So that is the second advantage for the inventor. Again, then again, like your friends who gets incentivized by seeing the teacher gifting something to the student who secured the higher marks. The moment your friend who is a researcher gets a patent, you also feel like, and then after that there will be companies coming negotiating with him, he will be getting royalty out of the innovation. So that's kind of kind of a, what do we say, it encourages the other researchers to come up with more innovations. So this is why, from the perspective of creator, the government is so much interested in your research or your innovation. Now coming to the third person I was talking about, that means people like me or the normal consumers. So why we are interested is, the moment there is a technology in the market, the moment there is an invention, at the end of the day, most of these technologies has to come to the market in the form of a finished good, or it has to be used. Like suppose it is something related to thermal power plant, some technology that need to be used. So I cannot say that no, I will buy it and buy it and keep it at home. It's not feasible, right? But even during an industrial activity, that particular technology is going to be used. So that is why industrial activity or a product coming to the market, it is actually always the consumer or the public who gets advantage of it. So that is why, not just that, after you get a patent, if you all know, within 3 years time you have to ensure something. Do you know what you have to ensure after, within 3 years of grant of a patent? Any idea? Government has given you a patent. So from the date of filing, you have a term of 20 years. You are the patentee, you are the king with related to that invention. But there is a condition. You have to fulfill something within 3 years. Do you know what is that?
No, ma'am, we don't know.
Within 3 years, you have to ensure that commercialization of the invention happens and the product is available in the market for the consumers. If you're not able to comply with this particular condition, government will revoke your patent. That means, what I mean to say, within 3 years time, after grant of patent, either you have to find a way wherein you will market the innovation invention yourself and ensure it reaches the market, or you have to license it, or maybe sell your patent to a company who can afford to produce it in bulk numbers and ensure that the consumers get to use it. This is a second condition. If you're not complying with this condition, no, government, they might have already granted patent, but you're not able to, inventors are not, companies are not getting enough confidence the way you are negotiating either your invention, or your invention is not that attractive for the company and you don't have money, that would end up in you losing the patent itself. So that is why I was saying, don't always hurry thinking that I want a patent. Think about all these things, think about the prospects, then only take a decision whether to apply for a patent or not. Because if you don't have the means to commercialization, and your invention, if the companies feel it's not going to be useful or it's not that great, then nobody is going to commercialize it. At the end of the day, all the money you have spent to get the patent granted in your name, you will lose it at the end of 3 years. So what is the point, right? So that is why the government says it's necessary, because at the end of the day, all the technological advancements are should be in favor of the public. They should get used to it, right? So that is why public is always a stakeholder when it comes to any research you are doing or any invention you are doing. See, for example, the vaccines, the patent that is there for vaccines, who is the ultimate beneficiary? I agree, companies are making a lot of money, government is happy that the public is getting access to the vaccines, but at the end of the day, the direct usage of the vaccine is done by us, the consumers, right? So that is why the public is always a interested party when it comes to any kind of inventions. Now, apart from that, when we talk about the next set of person or the next stakeholder, that is a government. What is the interest of the government? Interest of the government is not just incentivizing the inventor or ensuring that public gets access to the innovation. All these are there, or maybe getting some amount of tax money. Their ideology is much greater than that. See, you are granted a patent, and now I said that within 3 years, you need to commercialize it. Commercialization means you might have to set up a company or a factory or a startup, whatever you are going to call it as, that will bring in investment, right? Because you need investment initially to start a company. It might be a limited liability partnership, it might be a single entity company or a joint venture, whatever it is going to be. There has to be some amount of initial investment, right? Now the company is set up, factory is set up. After that, for in order to put the process into working, you need employees, right? Human resource is necessary, employment generation is happening. So that way investment is coming up, employment generation is happening, there are more entities setting up inside the territory of the country. Ultimately, all of this will lead to what? All of this will lead to economic development. So this is why incentivizing the inventor, increasing the number of inventions, making sure that the public gets access to the innovation, all that is fine. But all above this, why the government is so much interested in your innovation is just because of that. They want economic development in the country. So that is why they are extensively coming up with Make in India scheme and then Startup India and all those initiatives, because now we are at a juncture wherein if we need employment generation, we cannot rely on the foreign companies. We need to set up companies here, right? So that's why they are saying, come up with new ideas, start commercializing that ideas in India itself, and make sure that the economic development happens in India, right? So IP is one way of achieving that particular aim of the government. Now, keeping this in mind, when we talk about patent, what exactly is a patent? If you know, what is a patent actually differs from country to country. Why I say this? Like, for example, if you take the case of US, when I talk about patent, there you will even get a patent for a new variety of a plant or a new design of a prototype which you have come up with, or but or a software, new software which you have come up with. All that can be patented. But when I'm talking about the same patent under the Indian law or the Indian Patent Act, what happens? All these are excluded. You can get patent only for a new invention. and nothing else. If it's a software, standalone software, then it has to be copyrighted in India. Suppose it has a unique hardware along with the software, then there is a narrow scope that you might get a patent. And at the same time, plant varieties, we have a separate law which provides protection. Then designs, we have another law which provides protection. Semiconductors and integrated circuits also, we have separate law. So that is why in Indian context, when we are talking about patents, we are talking about what? Inventions. But still there are certain common factors which is common across the world. Just because when we talk about inventions, what kind of inventions can be patented? Because I said, right, it's not necessary that all the research you do need to end up in a patent protection, but more or less there are certain common factors. I would say four of them. Any country's patent law you take, usually this four factors remains the same. Mainly right after the World Trade Organization came into existence, and they in under the WTO, we have one agreement related to intellectual property. It's called the trade related aspects of intellectual property rights agreement on. So this TRIPS agreement is what has kind of made a lot of changes when it comes to intellectual property laws across the world. And to a certain extent they have unified the law, but still there are factors that have not been unified. Majority of that is related to your area, that is related to medical innovations, which we are going to see today. But this universal common factors related to patenting, or the characteristics that are necessary for an invention or an innovation for it to be patented, it is mainly fourfold. One is it should be an invention and not a discovery. Now I am very sure all of you might be very I think maybe more than better than me, you might be knowing about the difference between invention and discovery, right? Can somebody tell me, how do you differentiate between an invention and a discovery?
Invention is something which is
Yes,
something new, ma'am.
something new. Okay, and discovery?
Discovery is it already exists and we found out again.
Yes, exactly. So discovery is when something that is already existence in the universe or in the nature, it's just that we as humans never knew about its existence, or we never studied it. So at one point of time we find it out. Like for example, one of the earliest discovery is fire. And do you know which is the first invention we made? It's just that giving patent was not there, but invention was always there. So going by that logic, which was the first invention we made?
The invention of wheel.
Invention of wheel. See, why I asked about it is, when we talk about inventions, usually when you are not too much introduced to this patent system and all that, you always have a doubt inside your mind. When you come up with some kind of a research work, you always tend to think that, I don't think my research is that great wherein I will get a patent. Because that great means you might be thinking of great scientists who came up with breakthrough inventions. But one thing you have to keep in mind is, breakthrough inventions doesn't happen that often. The best example is wheel. Breakthrough invention was made by the early humans, and that invention still holds good. Don't we use wheel even now? It's just that modifications have happened in time to time, wherein advancement has happened at each level. The use of wheel, or maybe in terms of raw materials, there has been a lot of changes, but the breakthrough invention is still the wheel, which is found by early humans centuries and centuries back. So that is why it's not necessary that you need to come up with a breakthrough invention in order to get a patent. It just need to be modification. So that is why smaller modifications which has made that particular existing state of the art more efficient in terms of use. Because let's take in case of a medicine, earlier the situation that the whole dosage had to be given in a span of 6 months, and the efficacy rate was only 40%. There was 40% chance that in spite of taking the medicine for 6 months, your disease will be cured. Now you're making some modifications. So breakthrough invention is that particular medicine, right? which has to be administered for a span of 6 months, and which has only 40% efficacy when it comes to curing the disease. Now, the same invention you can take, you can modify it, you can do research, keep working on it, and you end up adding certain new reactants, chemicals, etc. to it, wherein the efficacy rate has gone up to 80%. Isn't that something good? Now, and not just that, from 6 months administering time, the time of treatment has come down to 1 week. That's something great, because earlier, if I had the same disease, I had to undergo through pain for almost 6 months. Still, there was only 40% chance that I would leave. But now you're telling me to undergo a treatment just for one week period of time, and there is 80% chance that the treatment is going to be successful. So isn't it something great? Is it something advancement? This level of advancement is enough in order to get a patent. So don't sit behind thinking that I didn't come up with anything breakthrough, because of which I might not be eligible for a patent. Breakthrough inventions happens maybe in 30 decades or 40 decades, there might be 2 or 3. That is it. You came up with 2G, and then all the developments that is happening up until 60 and others is just modifications of the existing system. But efficacy is there, because of which each of the generation can be patented. So that is why always when you are doing your research topic or your research project, understand what is exactly the state of the art, latest state of the art that is existing, and think about what modifications you can do it, so that whatever use it is intended to be, it becomes more useful. It might be for the public, it might be for a set of stakeholders. You want to make them more useful to them. For that, what you can do, you just have to concentrate on that. Your research will be an innovative research, right? So that is why breakthrough invention is not necessary. You just have to ensure that whatever advancement you have added to that invention is new and novel. It was not the state of the art before. The expert from the field didn't know about it. That is enough. And then efficacy also need to be there. That means that is exactly this inventive step is. If you are just adding two, see, I am telling you, so far the medicine was used to be in liquid form. You have just converted it into tablet form. In that case, I cannot claim that there is efficacy. There are certain standards and criterions depending on the nature of the invention or the field of technology you're talking about. But as long as you can give assurance that, okay, from the existing state of the art, I have done an advancement which has made the whole process simpler or useful, that is enough to claim a patent. Always keep that in mind. Breakthrough inventions are not necessary. We are not expecting all of you to be Einsteins or any great scientists. Make advancement, ensure that the whole process has become simpler or more useful. That is all that is expected from you, right? Now, this, not just that, the last criteria is, so we have talked about there should be an invention should be new. Not new to me. I'm just a person who just, my background is law. I know only the legal developments. So if you take something from fluid mechanics and you are telling to me, unless I do research, I won't even know whether there is scope for getting a patent for it, even from your field also. So that is I am not the judging criteria. The expert from the field is the judge to say that whether it is a new invention or novel invention. Then apart from that, there should be certain level of efficacy or usefulness. Now, the fourth and the major important criteria to get a patent or subject patentability criteria is that there should be industrial application for the invention you are coming up with. What I mean to say is, it should be useful either in the course of an industrial activity, like for example, you are coming up with a medical device which can be used for the diagnosis or a disease, or an information system which can be used for collecting information of the patients or about a specific disease, etc., etc. So there, if it is a device, medical device, then we might be able to produce it in mass, and we might be able to use it on a commercial level, right? Or it might be some kind of a, like, CT scanner or some advanced technology related to that. So in such cases, it's not necessary that we need to produce it in lakhs and crores of numbers. It might not be necessary. Just depending on the cost and other factors, there might be just 50 pieces or 100 pieces that would be necessary, but still it is using in a service rendering or commercial activity. Or it might be some kind of a machinery which is used in maybe creation of API, active ingredient for medicines. You have made a device which can make the whole process easier. So there, it's not necessary that customer has to buy your machine and keep it at home. No, in the industrial activity of production of that particular API, your process or your product is being used. That is enough, right? But industrial activity or some connection with industry need to be there. Because why I'm saying is, I'll tell you an example. I'm making a very destructive atomic bomb, and I'm saying, give me patent for that. So government will say it's an invention. Yes, it's an invention. It has novelty. I'll say it, yes, it has novelty. It has efficacy. Yes, it has efficacy, because it can cause more destruction than a hydrogen bomb or nuclear bomb. Now the question is, will we as consumers buy it and keep it at our home? No, there's no commercial activity as such, right? So that is why always ensure that whatever invention you're coming with, it should be useful to somebody. If you can just invent something, make it at home and keep seeing it, government is not going to give you patent, right? So that is why always keep this four things in mind. And now we will move on officially to our area of study, that is this medical inventions, and why exactly we deal with medical inventions separately. Because when we talk about innovation and technology, there can be innovation and technology in the, it can be in the field of nanotechnology, artificial intelligence, softwares. It can be in the area of mechanics, and you will be knowing about better about other areas. But the problem is, I said that these four factors which we have been discussing so far, they are universal criteria. They usually don't change depending on the country where you are planning to grant patent. It almost remains the same. But in spite of fulfilling all these criteria, still you might end up not getting a patent. So that is why I said that it's not possible to get a universal patent in your name. You have to go to each country and get the patent granted in your name. Why? Because depending on the religious perspective of a country, depending on the ethical, moral principles, legislations, other laws in a country, usually there will be restriction with regard to patenting of technologies in specific areas. I'll give you an example which is not related to your area for your understanding. That is atomic energy. See, if you look into the patent law, like, if you want to patent something in countries like US, European Union, China, and if your invention is from the field of atomic energy, usually you won't face much problem, unless it is usually when it is involved with, like, the treatment of radioactive waste, or generation of radioactive metals, etc., etc. Some small regulations are there, but usually you might end up getting a patent. But the same patent application, suppose you are filing it in India to get a patent in India, then what would happen? The patent office will right away reject your patent. But why? If you can get patent in US, if you can get a patent in China, or maybe in South Korea, why not in India? That is because in India we have specific provision under the patent law which says that the moment your invention is directly or indirectly related to another law, we have another law of 1961 which talks about dealings with related to atomic energy. So the moment your invention is related to atomic energy, you will end up not getting a patent. So your invention will be new, it will have efficacy, it has industrial application, but still you won't get a patent, because government will say, see, your invention is related to what? Atomic energy, and we have specific provision in our patent law which says that innovations related to atomic energy cannot be patented. Same goes with another example. See, you might have seen these movies, right? I think there are a lot of movies even in regional languages. Hindi, there'll be a village or a tribal area, so the hero or heroine goes there stays with them and understands their culture, and since it's movie, so there might be some other storyline also, but at the end of the day there will be some kind of a, usually it will be related to some traditional medicine. They might be knowing some use about it for treatment of a specific disease. They'll study about it, and usually how it shows is happily they'll come back to the city, and then we don't know what happens. But usually when, since we deal with IP, since we are IP lawyers, we knows what happens afterwards. The person will go, they'll do research in their research facility, and they'll come up with a medicine which can be produced in laboratory conditions, but the knowledge related to the medicine will come from these traditional communities or tribal communities. So that is why, and countries like India, Brazil, Africa, we still have a lot of traditional knowledge, because we are rich in terms of traditional knowledge than traditional health systems. So that is why if you look into the patent law of these countries, mainly developing countries with traditional knowledge, you will find that if your innovation is directly or indirectly related to any traditional knowledge, you will not get a patent. But you won't see such similar provisions in the patent laws of US or maybe European Union, Japan, etc., etc. So that is the reason why I said it is never possible for somebody to say, if you're showing your invention and saying, tell me how many countries I can get a patent, it's not possible. We have to look into the legal system, compare your invention, and then only we'll be able to give a expert opinion. So this is actually an advantage, because sometimes those of you who are planning to go into academics, usually one problem they face is that, because they also have criterias, you should have patents and publications and all that. So they look into just getting a patent and not maybe not much into commercialization. At that time this kind of situation can be a hindrance, because it says in India you cannot get a patent. So you don't have to stop there, you can just get your patent filed in some other jurisdictions or countries, right? So still there is hope. Now, coming to specific about talking about medical innovations, before saying that, I'm going to tell you why this restrictions related to some innovations cannot be patented varies from country to country. So I have you gone through section 3 of the Patent Act, patentability criteria? Are you aware of it, at least few of them?
Yes, ma'am.
Yes, whichever you can recollect, can you quickly say it so that we can skip those?
Basically, it deals with objections which are the products cannot be patented. Those
Hmm.
things.
Yes. So which are few? Can you recollect few?
Ma'am, recently we had same thing. Same thing we had, ma'am. In that also, ma'am said like aspirin was a tablet which were patented just because it was used for the purpose of curing headache. Now, if
What
someone
is that?
claim it acts as blood thinner, it cannot be patented again.
All right. Okay. So
Such
why is that? Why is that?
because the method of producing the aspirin in both the cases might be same. So
It's the new use, right? Aspirin was used for something. Aspirin as a product was already patented. So you're coming up with a new claim that it can cure one more. I think recently there was a study that aspirin can be used in cure certain instances wherein the patient suffers from cardiac arrest. But aspirin, already we knew about it almost 100 years back, it was patented. So that is why it is a new claim that you're coming up, or new use you're coming up. So how can you get patent, can you get a patent for that? Still there is difference when it comes to, or when the jurisdiction varies from country to country, right? Still there are countries wherein there is scope for protection of such patents, but not in India, because for us, first second use claims, or even first use, only first use claims are allowed, second use claims are not allowed, isn't it? Yes. And then anything else you remember?
that's it, ma'am.
All right. So what we do is, in that only specific instances related to your area is there. So I will show you just quickly what were they. If you want me to explain anything in detail, you can ask. Otherwise, we'll just brush through the slides. Okay. Uh, yes. This was the first one. 1 second. The first one, that is frivolous inventions. So even the ones related to medical field, the moment your invention cannot be used there, then it might come under frivolous inventions and you cannot patent it. Then inventions contrary to well established principles of law, then you have inventions. Yes. Now coming to the third one, that is inventions which are contrary to public order and morality. This is where we are going to talk about medical ethics in the first instance. So when we talk about medical ethics, what do you know about medical ethics so far? What is this medical ethics? What do you mean by that? Why there is something known as medical ethics?
It might be there, like there may be like they can do some like something is allowed and some things are not allowed in inventions or anything.
Okay.
So
Yes, yes.
for that purpose, medical ethics.
No, in general, what does medical ethics indicates? Leave inventions. Talk in general about medical ethics.
Prevent unhealthy practices in the medical fields, such as female feticides and other unethical
Good, good, good. Yes. So
practices.
basically, yes. So this it is basically a code of practice which was initially formulated for the medical practitioners, midwives, etc., etc. The problem here is that this field of medicine, they consider it to be a sacred profession wherein you cannot concentrate on profit alone. So that is where the whole concept evolved. So the moment you're working on a you're working with a patient, you should not have profit motive. Your motive, that I mean to say the doctor or the midwife or whoever it is initially, their motive should be to save the patient. So for that, you are not supposed to indulge in certain practices which the medical experts used to consider it as unethical. And if you look into, there are international organizations who looks into this code of ethics, and they keep refining it as and when it's necessary. Like every 2 to 3 years it gets they keep changing the criterias, because there is advancement happening in technology, there is advancement happening with regard to the perspectives. Like for example, and one example outside the sphere of innovations, if I'm talking about, is related to gender justice. Because earlier under the ethics there was no practice with related to how a patient who is a transgender or a third gender need to be treated. But now the Medical Council of India, as well as under the international level, they are coming up with certain ethical practices with related to affording treatment or giving treatment to such patients. So that is why it is never constant. It keeps changing as based on the changes that is happening in the society. Now the problem when we talk about medical ethics is that it is always in favor of the public. When we talk about medical ethics, it is always in favor of the patient or the public. The safety of the patient or the interest of the public comes first, and then the doctors, and then comes the corporate entities or the hospitals, whatever it is. So first preference is always to the public when there is something related to medicine or treatment or some sort of a thing comes in. So this should always be there in your mind. Now the question that comes is, when you're working as innovators, when you're working with an R&D department of an entity which is related to which produces medical devices. For example, let's say, why exactly you should be bothered about medical ethics? Because you are not seeing the patient directly, you are not collecting any information from the patient, etc., etc. You might be getting such thoughts, but that is not how it works. Because when we talk about innovations in the field of medical science, we can actually divide them into different categories. So first, let's look into the kinds of medical innovations. Then we'll take each one of them, because not all of them are important to you, because you don't deal with all of them. Like for example, if you look into the kinds of medical innovations here, the first one is the medicines, pharmaceuticals, vaccines, etc. So usually when you work with this only indirectly, you might be involved in the technology used in the production of vaccine, or the underlying technology related to production of a medicine, or something, some kind of a something similar to it, but you will never be directly involved related to medicines or pharmaceuticals. Then comes but in terms of research and revenue generation, this comes first, because it can medical devices, the problem is there is a lot of innovation happening, wherein even if you get a patent within a span of maybe 2 years, sometimes within 1 year, sometimes at least 5 years, that's it. Within that, the technology will become redundant and there'll be some new state of the art coming up. So medical devices, the problem is they are important, but you cannot just enjoy your patent for 20 years. By 4 year, 3 year, 2 year, there will be an advanced technology that will be already that would have come to the market. So that is why. But medical devices are also one kind of medical innovations. Then there are something known as medical methods. Now this medical method, usually you don't deal with at all, not directly, because that is dealt by the doctors. Like for example, a way of a therapy wherein a disease can be cured, or maybe a mode of administering a vaccine or a medicine, or maybe a method of diagnosing a disease. So this majorly talks about, we also call them as medical process inventions. And the most strict restriction with related to patenting is related to medical methods, because it has more connection with medical ethics and right to health. And then you have a relatively new field of innovation in the field of medical technology, that is innovations related to information management. For example, I'm not sure whether your field deals with it, but if it can be a combination of second and fourth also, so there are chances. So now in this, what usually does is in terms of hospital database management, patient database management, clinical trial database management. Say they might come up with something very innovative, use of blockchain technology, artificial intelligence, etc., etc. So in that case, it can belong to the fourth category. And out of all the three, in terms of restrictions when it comes to patenting, the least restriction is for the last one, that is innovations related to information technology, as long as it doesn't get associated with any of the previous three forms, that is either pharmaceuticals, either devices or methods. If it is independent from the rest of the three, then usually there won't be much restrictions when it comes to information management, innovations related to information management. Because only problem that they need to worry about is when we talk about innovation management databases, what actually gets saved is what we known as critical personal information. Because what are the diseases I have, what is my health condition, these are very sensitive data for an individual. So, and we live in a country where we have certain fundamental rights, right? Have you heard about fundamental rights?
Yes, ma'am.
Yes. So do you think when you deal with medical innovation, which form of fundamental right comes in, which kind of fundamental right? Information. See, the hospital, when you go, they'll prepare a chart for you, either online or offline, they'll keep it there. And if the hospital is not allowed to give it to anybody without your permission, why is that?
Individuals' privacy is exploited.
Yes, because the Constitution of India guarantees you right to privacy. So anything in the course of medical practice, which is either by a doctor or an institution which deals with medical practice, without the consent of a patient, if they discloses any kind of confidential information related to the patient to a third party, then that would go first against why it is violation of your fundamental rights, and it's also violation of the medical code of ethics. So that is the first case when it comes to information. And since I'm talking about so that is when you're dealing with databases, you have to be very careful. So even you might have seen, if your projects or something, if you go to hospitals and ask for certain information related to patients, they will not give you. This is exactly the reason, because it is against medical ethics. First of all, that is sharing confidential information of the patient, and again, there is a right to privacy of the patient as enshrined under the Indian Constitution. It can become very it can be a very serious instance wherein such kind of any such violation happens through any hospitals or doctors. Now this information which I'm talking about, that means information related to patients, etc., it can be important even when you deal with medical devices. So I'm just jumping to the second form, because first one, anyway, even if we discuss, it won't be relevant to you, but that is what we discuss more when we talk about innovations in the field of as lawyers, when we talk the most about medical medicines and pharmaceuticals, because majority of the patents are related to that, majority of the innovations as well as research happens related to that. But medical devices, when we are talking about, since I think 2014, as per the data, there is almost 170% increase in the number of patent applications that is filed yearly in terms of medical devices. And not just that, just because this regenerative medicine technology, stem cell research, and all those things are developing, what they're predicting is that there can be more advancements in the field of medical devices in the coming years. That's what we are expecting. We don't know exactly what will happen, but that's the expectation exactly, and that's why now we have started focusing on medical methods and devices. So medical methods and devices, there is a connection between the two. You need to understand that, because usually what happens when you file your patent applications, it might be for a medical device, but your patent application will get rejected, because when you if you remember, in your patent application, in the complete specification, there is something known as claims. Have you been introduced to it? Have you seen a complete specification, a complete patent application? Have you seen?
No, ma'am, they haven't come to that.
All
yet.
right, all right.
Yes.
So, see, what happens is, this patent applications which we file, no, they are basically the documents wherein you do the disclosure to the government, saying that, hey, this is what the innovation I have done. I'm disclosing it completely to you. So, the quality of disclosure which you are making as the inventor, no, to be to such extent that without your consultation, because you are the inventor, right? Without consulting you, an inventor from the same field should be able to replicate the process or the product. So basically, if there are any diagrams, drawings that are required, then that should be part of your application. Not just that, if the innovation is related to biotechnology, sometimes it might be a modified microorganism. In that case, even the microorganism will become a part of your patent application, and we have repositories. Unless and until you reposit the samples of the microorganism in the repository, your application is not complete. And sometimes, if it is such a complicated invention, they might even ask you for models of your innovation. So that is why, so when I talk about these patent applications, usually it's a techno legal document, but usually people from the field of I think I don't have it, I can show it to you. I will send you after the class, maybe some samples I have. I will send it to you. Maybe if it's related to your field itself, one or two inventions. I can share it with you so that you'll understand. So when we talk about these patent applications, no, usually we call them as techno-legal document, but almost 98% of the patent application is technical in technical part. Like for example, it will ask you what is the title of your invention. Then you have to say what exactly you are calling your invention. Then it will ask how exactly your innovation is better from the existing prior art, or what is exactly the problem that was there in the technology which you are trying to solve, which you have to explain. After that, right from the beginning, what are the materials required, how do you're supposed to perform the invention in detail, you have to write. So this is the first part of the invention of your patent application, which talks about the technology part. Then there is this 2% part at the end. Usually it should be at least 11 points, 11 sentences. If you want to write more sentences, then you have to pay more money. That's what they say. So in this 11 points, what you're trying to do is, we call it as claims. Usually that is where you require the help of a person who is experienced in the field of patent or law, because that establishes your right. Because what I'm trying to say is, suppose you have come up with an invention which is a product which is new and novel. At the same time, the process of making it is also new and novel. So basically the idea for you here is, you want to get a patent for the process of making X as well as for X. You want a patent protection for the product X as well as the process of making X. And then you wrote your patent application, you wrote everything in detail, how to make X and what is the benefits of X, everything explained in detail. But when you wrote your claim, no, you forgot to write, you wrote your claim as, okay, you wrote your claim just like this: the process of making X in the course of industrial application, or in the course of this particular technology. Since you want to get a patent for the product also, there had to be a second claim saying that patent protection for X. You forgot to mention that. You only mentioned process of making X. Then what would happen? They will give you a patent because it's new, novel, and all that, right? And then comes the problem. Your friend will get the information because it's already published in the public domain. And your friend will start, friend, what he will do, he'll come up with a second process, which is not related to yours, an entirely different process, and he'll start making X. Then you will go to the court saying that, see, my friend, he is infringing my patent. I have a patent for this. Only I can make X. I can sell X. I have a patent for box. Then what the court will do, court will not look into the whole of your patent application. They'll look only into the claims part. And then they'll tell you, see, in your claims, you have asked for patent protection only for the process of making X. So you know a process through which you were making X, which was new, for which you have got a patent. But for the product X, you never asked for a patent because your claims, you forgot to mention it, right? So that is why your friend making X through a different process will not be violating your patent rights, in spite of you having the patent for, in spite of you filing a patent for X. So that is why claims is usually an important part of a patent application. So usually what happens, this medical devices and medical methods are interconnected. Like for example, I'll give you one example. You might have heard about dialysis, right? What is dialysis? Dialysis.
It's like it's an artificial kidney which removes excess of urea from the body.
Okay. So when I say dialysis, dialysis refers to a medical method. So what happens in the procedure, dialysis procedure, is that it does purification of blood, which is usually done by the kidneys. So because of either transplant or some other disease related reason, when your blood cannot be purified by the kidney, then there is an artificial procedure wherein purification of the blood can be done in a institution. That is exactly known as dialysis. So that is a method or a procedure, right, of purifying blood. So that, if dialysis, the when it was invented back then, it will come under the category of medical method. That means the process of purifying the blood, right? Method of purifying blood artificially. So now for that means the method of purification of blood, there is no concept of getting a patent, because it is a medical method or a medical procedure which is used by a medical practitioner. You will not get a patent. But the device, like initial device which was invented for the purpose of doing dialysis, you will get a patent. So that is why distinguishing what is the method and what is the device is very intricate. Because what will happen in your patent application, if you write a claim as method of doing dialysis, they will say no patent, you go home. But instead of that, if you write it in such a way, you're saying device for doing purification of blood through dialysis, that means you're saying I have invented a device which is new, which can perform the dialysis. Give me patent only for the device. I'm not asking patent for the process of dialysis. In that case, you will get a patent. So that is the problem here. Always when you draft your medical device claims, you have to be very careful, because I am telling with practical experience, in India usually what happens, we don't take care of this distinction carefully, and we simply file patent applications, and then at the end it gets rejected, because there will be one place wherein you will claim that medical procedure also as a under patent protection. So that is why that is completely related to because why medical methods are exempted from patent protection is because that comes, or that will hinder medical practice. The process of doing dialysis, or the process of injecting a medicine, the process of injecting IV, open heart surgery, that is a medical method, or your keyhole surgery, that is a medical procedure, or a particular way of treating cancer using radiation technology. That process is actually a medical method which is usually used by medical practitioners. So medical ethics, by applying the principles of medical ethics, you cannot commercialize that particular act that is used by a doctor or specific way of diagnosing something. But the instruments that are used in the course of these methods, it might be a surgical method, it might be a way of administering a vaccine, it might be a way of diagnosing a disease, anything during the course of using these methods. If you are using a device, like for example stethoscope, it's a device, medical device, which was patented initially. Even now you get newer forms of it with technological advancement which can still be patented. Thermometer is a device, medical device, which can be patented. Then similar wise, there are a lot of devices, stents, right, which is used in surgeries. They are also, that process of inserting a stent is a medical method, cannot be patented, but stent as a medical device can be patented. So that is why when you're involved in research with related to medical devices, you should be very careful, because you should never claim in your patent application, you should never claim that you want patent protection for the method also. You should ask patent protection only for the device, right? So that you have to keep in mind. Why? Because what matters for a government when they grant patent is the public health. See the situation in India right now. There is a lot of treatment protocols that the doctors are coming up with related to a combination of medicines. The medicines will already be patented for the purpose of COVID. There were a lot of combinations they have come up with, wherein they are saying that if you use the combination of X and Y medicine and administer it in a patient who is having symptoms of COVID, then the symptoms might come down, or certain cases his life can be saved. So that combining two drugs, both the drugs might be patented, but that information wherein they have found out now that if you combine this two, you might get a cure for COVID. That particular aspect is something related to treatment. It's a medical method or a medical procedure which cannot be patented. So distinguishing what constitutes a medical device, and drawing the line with the procedure of treatment or procedure of diagnosis is very important when we talk about medical innovations. Because medical devices are free. You can always go for patenting, as long as you are not trying to get a patent indirectly on the medical method also, because that is very important. So let's go back. I'll explain it to you in detail, because these are the two areas which you need to keep concentrating or focusing on. That is how exactly you distinguish between a medical device and medical methods. And not just that, there are several instances wherein what actually happens is that indirectly you ask for claims, because it is advantageous when you get a method as well as device patented together. There are chances that you will end up earning double or triple the amount of profit, but then it will go against the principles of medical ethics as well as medical practice, because you will be hindering the doctor from venturing into that particular procedure. So that is the reason why medical methods are completely kept away from the purview of what? Completely kept away from the purview of medical, patents. You cannot get a patent. At the same time, you cannot mix medical devices with medical methods and ask for a patent also. Now let's come to this medical devices. What happens? Medical devices, it is also important. Have you heard about FDA in US? FDA approval, you might have seen in
Yes,
this
ma'am.
Netflix series and all that, right?
Yes, ma'am.
Yes, ma'am.
All right. So medical, FDA, what do they do? Do you know?
They approve the drugs, ma'am. Like they test for the drugs on various animals and they approve whether it is
Yes.
viable for human beings or not.
Mm. FDA, they not only approve the drugs, they also give approval for these new methods of surgery, then methods of diagnosis. They also give approval to medical devices also. So that is why, see, that's what I'm saying. You might apply for patent, but this is a classical example wherein you will get a patent and still you won't generate any income out of it. So what actually would happen is, in India, you will apply for a patent. Your patent application, they might be processing at the same time. In India also, there is a equivalent organization like how they have FDA in US. It is called the Drug Controller of India. You might have read about him in the newspaper recently, saying that he gave approval, emergency approval for X vaccine, Y vaccine. So this same person, it's quite an old law. It's called as the Drugs and Cosmetics Act of 1940. Under this particular law, for any kind of medical device, cosmetics, medicines, medicaments, anything related to that, you have to get approval from the Drug Controller General of India. So what usually sometimes can happen, if you have, even when you do clinical research, mainly sometimes your medical device, the nature of the device will be such that initially when you start the research itself, you have to start the clinical trials. When I'm specifically talking about these prosthetic limbs and other things which you come up with, the kind of technological advancement that has happened is such that you have to initially itself talk about clinical trials. There might be patient information that is necessary. You would need even subjects for your clinical trial. So in that case also, you need approval initially. Simply you cannot start with the research and go apply for a patent, because patent office also will look into whether you have taken sufficient approval for the research. So that is why initially you have to start your research there, getting sufficient permission for clinical trials, use of subjects, etc., etc. And such information has to be submitted to this particular person called as Office of the Controller General of Patents. So this is not related to intellectual property, but this is a simultaneous procedure which you should be complying with when you're dealing with patients or when you're using information. Because any kind of medical device, even if it gets a patent, it cannot be marketed or it cannot be made and imported to other countries without the permission of whom? Without the permission of the drug controller. So keep that in mind, because if you miss out on that, you might end up doing something illegal. So this is an additional restriction sometimes on the students and researchers from the field of medical, who are into medical device and innovations related to that. Because if you're talking about your friends from the field of mechanics or electronics engineering and all of that, they don't have this problem. But there are chances that if you don't take sufficient precaution right from the early stages of your research, you might end up doing something illegal. So look into all those things and then only start your research, because I said right of patients is of paramount interest when it comes to all these people. May it be the doctors, may it be the medical fraternity, may it be the legal fraternity, or even the government. So that is why the area you deal with, that means research related to medical devices, research related to medical electronics and all those things, it can become very sensitive, right? So with that, we will come back to, so think about this FDA approval and all those things whenever necessary. Now we will go back to patents. Now, ma'am, are you there?
Yes, ma'am, I'm here.
Is it too late? Should we? I think it's almost
5:50.
Yes. Should we just keep another session? Because if I want to show them examples and patent applications, it would take some time.
I don't mind, ma'am. Yeah, can you, if you are okay with it, yeah,
Yes,
absolutely fine.
then I think that would be better. Let's not bombard them with too much information.
Yeah.
Yes. We'll.
I think if you are okay with it, we can have more detailed session on medical ethics
Yes.
individually.
I can finish it with this devices and methods
Hmm.
specifically, and medical ethics. We can finish it in the next session. I think that would be better. Otherwise, it will take another 1 hour or 1.5 hour. It will be. I don't think they would able to listen.
Yeah, I know. That
Yeah.
should not give way for that
So,
response. We shall make sure they'll get the benefit of your inputs. And we'll coordinate, ma'am, then. Whenever you
all
say
right.
you're
Okay.
comfortable, we'll arrange, ma'am.
Yes. Then anything which we have discussed so far, if you want to discuss something or have any clarifications, you can ask in detail with related to medical devices and the ethics related to that. We'll take up in the next session.
Doubt, ma'am.
Yes.
Ma'am, what if some company had known someone's invention and use it without giving royalty to the inventor? How can the inventor seek justice?
Okay, so you are saying about invention, right? You invented something. I am the company. I got to know about your invention and I started using it. So if you're just an inventor, it is going to be difficult. I would say very narrow chances that you might be able to take any remedy against the company. That is why they say first, the moment you have a little bit of invention itself, go any details, you go file a provisional specification and protect yourself. Because the moment you have a patent or you have applied for a patent and then the company is doing it, then what happens is that in that case you have sufficient remedies under the patent act. You can punish them, you can get a lot of compensation from them, because that is also one way. And I will tell you one more thing, usually why this question might have come up. I'll tell you from the perspective of students in the final year. Some of you might come up with projects which are very nice and innovative, wherein you would want to find investors for your research. And usually the students, they face a problem here. They wouldn't know how to proceed, and there are certain this angel investors and others out there. They might take you into confidence and they will try to get information out of you. So you might not have filed a patent by that time. I'm not saying don't disclose information. Disclosing information is safe even at that time, even if you have not applied for a patent. But there is something known as an something known as, I think you might have heard about it. It is known as NDAs, non-disclosure agreements. Have you heard about it? So this is basically a contract that will be signed between two parties, wherein they say that anything that is going to be revealed to you during the course of conversation, it should be kept as a confidential information. And if the other party wants to do something with related to that invention, always they have to take prior permission from the owner of the invention. So in this way, even if you are planning to apply for patent in future, or even if there is a some trade secret involved, you can always protect your stand as an inventor. So it's not necessary that, because at that time, for when people are working with startups and other things, we cannot really afford to wait till you get a patent or file for a patent. You'll have to right away start negotiations and other things. So that is why make use of these non-disclosure agreements. You can also get the formats of it from the college also. We have distributed it to your innovation cells, entrepreneurship development cells and all. Or you can walk back directly to the IPR cell also. So we'll provide you with the format of the non-disclosure agreement. You can sign this non-disclosure agreement, and then disclose information to whoever you want. So in that case, even if they try to use your information, we can claim compensation from them, we can hold them accountable. But without signing a NDA, if you're going to disclose information thinking, oh, he is my friend, then we are going to be in trouble. Shashidhar?
Yes, ma'am. Thank you. I
Yes.
understood.
Yes.
Any doubts, students? Yeah. Thank you very much, ma'am, for your valuable inputs. In fact, and it was quite vast. I think breaking up will certainly help them out in a great sense. So we'll surely have the next session. I think if ma'am is okay with it, we can have it tomorrow itself, or we'll have it sometime
Ma'am,
next
we'll
week.
look into the date. I'll let you
Yeah.
know. Yes.
Yeah. You please let us know the dates, ma'am.
Yes.
And I'm waiting for the next session. We'll end up the session today. Thanks a lot, ma'am. Thank you very much.
Thank you. Thank you, everyone.
Yeah, students,